Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call, in which we try to answer the community's questions as best as we can. We have many more callers than we usually do. Some of it may be because of the nervousness everybody's feeling about Trump. And I just want to note that there is nothing yet on legal immigration from Trump. He has suspended all regulations that have not yet come into effect, but there's nothing about regulations that are already running. So I've been asked questions like, is my advance parole getting affected? And I don't see it like that. I think the part about advance parole or parole really in the executive order doesn't have anything to do with advance parole. But again, I'll withhold judgment. With this administration, I don't know what is up and what is down. Thank God for courts and thank God for public opinion. They are still manageable, but the administration is really, they're doing things that are very difficult to understand or to explain. Okay, now that said, I want to note again for the record, folks, I will not be taking new questions. I don't think I'll have time. So if you're expecting me to, I have to leave at 1:30 exactly. We have a lot of questions today that I consider to be frequently asked questions. So let's get started without any further discussion. First one is, can I travel after I apply for naturalization and citizenship? And the answer is sure. Sure, you can travel. The only problem is there are some rules, the same rules that apply to green card, they don't stop applying just because you applied for naturalization. So if it's just a 3 weeks vacation, I don't see any problem with it. If you're going to be gone for several months, please talk to a lawyer. Make sure that it's not affecting your naturalization or even your green card. So let's read through the question from NPS. She says, my husband and I are planning to apply for citizenship. I've had a green card for 9 years. We want to travel to India for 3 weeks. That's not a problem. Can I travel after filing? Sure. Should I plan then after biometrics, or can it be before that as well? As long as you appear for biometrics or request that biometrics be rescheduled, I don't see any problem. The green card expires on November 2017. I don't think that matters either. Also, is employment necessary or helpful when applying? No, it's not needed. As long as your taxes are paid up, I don't see any problem. Do we have to reside in USA 3 months at a stretch? About the domicile requirement, remember the 90-day domicile requirement is actual 90 days. There are states that have taken a different approach to this. I can't really get into all that. We don't have a lot of time to go over the details and the legal nuances. Suffice it to say that I don't think a 3-week absence is going to cause a problem in the domicile requirement. But if you want to be overly cautious, you can come back and stay an extra 3 weeks before you apply. Any questions on this, press *5. No new questions. Any questions on this, press *5, please. *5 if you have a follow-up question. There is one follow-up question. All right, let's go to that. This one is from Columbus, Ohio. Go ahead, please.
Yeah, so if I understand it correctly, you basically said that a 3-week vacation wouldn't affect the process. So it is fine that we go ahead and submit our application and then we come back and apply to the biometrics?
Yes, sir. I believe so. I don't see any problem here. Okay?
Okay.
Good luck.
Okay, thank you.
You're welcome.
Thanks.
All right, let's go on to, we're done here. Next question is, and this is from Jatin. Jatinji wants to know the retroactive effect of the new regulation. So let's say, for example, the regulation started on January 17th, right? On January 17th or 18th, let's say, my 180 days of I-140 pendency are over. Do I have to start 180-day count from January 17th? I don't think so. I think if you have arrived at 180-day mark on or after January 17th, you should be covered by the regulations. Your second question was, after completing 180 days, if I change the company, can she get her H-4 EAD extended based upon the approved I-140, which remains valid even if employer withdraws it? I have not seen yet a definitive statement on this very fine-grained point. The point is this. Let us say that after 180 days, my employer withdraws my I-140, and then I change to another company, or after I change to another company, the employer withdraws it. Can my wife still get an I-140 EAD because my I-140 is considered to be valid for at least extending my H-1 and for keeping my priority date? And the answer is, I don't know if H-4 EAD will be granted under these circumstances. There are a different set of regulations. I do not believe USCIS kind of looked at that regulation and how it can interplay with this one. So my guess would be, this is just a guess, unless USCIS gives us a policy statement somewhere along the line, this is up in the air. Star 5 if you have a follow-up question on this. I've covered both things. Star 5. Okay. I have one. Any other? 2. And these are follow-up questions. No new questions, please. Okay. 3. Okay, 3 follow-up questions. All right. Let's go first to New Jersey. New Jersey, go ahead, please. New Jersey.
Yeah, hello, sir.
Yes, ma'am.
So you mentioned that even if the previous employer withdraws the I-140, I-140 will still be valid.
Yeah, that is the new regulation. I would strongly encourage you to go to my blogs. If you go to immigration.com and you filter down on the right hand side to the blogs, scroll down, and I have I put the text and comments on Trump's executive order also. Supplement J, which is the new form. The Grow American Jobs Act, the one they want to affect the H-1s on. The new standards for national interest waiver. And the one that is very important for you is I-140 EAD regulations. If you click on that, there's one minor typo, but other than that, I have a complete chart of how everything got affected. So if you click on that kind of a picture, like an infographic, it tells you exactly how the whole process works. I would strongly recommend that you take a look at it. Okay. The law is basically, it says that if your I-140 is approved, you are immediately entitled to your priority date, even if your I-140 is later on revoked by the employer. Unless the revocation is by USCIS for fraud or misrepresentation, you will keep your priority date even if the I-140 is revoked before 180 days of approval have passed through. The second thing it says is, if the I-140 is approved and stays approved for 180 days, it is not revoked, then not only you keep your priority date, you also have the right to keep getting H-1 extensions on 3-yearly basis with any employer. Clear?
Okay. So even if I don't get into the stage that I-140 with the new approval, I still go eligible to get a 3-year extension.
Yes, ma'am. Even if you have no other I-140 approvals, the fact that in your history there was an I-140 that got approved and stayed approved for 180 days protects you from every angle. This is a very good regulation.
Okay.
All right.
Sounds good. Thank you so much.
You're welcome. Good luck.
Thank you.
Okay. Let's go on to Illinois. Illinois, go ahead. You're on the phone. Illinois. Illinois.
Hello?
Yes, sir. I can hear you.
Yeah. So, sir, my thing is again on the H-4 EAD part. Since H-4 EAD got granted based on the approved I-140 only, So again, if it's on a withdrawn state and it's still valid, can we apply for the extension of EAD or no?
Let me separate you from these regulations and let me take you back to the H-4 EAD regulations. By the way, they have been discussed at great length in my blog. So if you go to my blog and look at the H-4 EAD regulations, not only are these discussed in all these questions that you're asking me are already there on my blog. Remember, government said if we approve your wife's EAD today based upon an I-140 approval, and tomorrow that I-140 gets revoked, we, USCIS, reserve the right to revoke your wife's H-4 EAD. Will we ever do it? We don't know, but we reserve the right. Can you get an extension? Under the old regulations, no. You need to have at least one I-140 alive if you want to get extension. Under the new regulations of the I-140, since your I-140 remains alive for keeping your priority date and for extending your H1, even if it is revoked, does a revoked I-140 also stay alive for the purposes of H-4 EAD or H-4 EAD extension? That we don't know yet. Okay? Am I making sense?
Oh, okay. Thanks.
Okay. Good luck. All right. As we were talking, there were three other hands raised. So, guys, no new questions. If you're asking a new question, press *5 and put your hand down. Only follow-up questions, please. I may not have time for new questions today. Okay, let's go to Pennsylvania. Pennsylvania, go ahead, please.
Yeah, hello, Mr. Rajiv. In light of this new rule, how would it work for future employment if somebody has sponsored and
The same rule.
140 is approved?
The same rule. Whether your employer is your current employer or a past employer or a future employer, if the I-140 is approved and stays approved for 180 days, you are covered.
Oh, okay. So I can port that future employment 140 to a new employer and still use it.
That is correct. Yes, sir. Okay.
Okay. And also, this portability, the new employer still has to start the fiscal process all over from PERM, right?
Yes. You are not exempted from refiling the green card. That comes only if you are covered by AC-21 portability, which is I-140 approved, 485 pending, 180 days, same or similar job.
Mm-hmm.
Okay.
Okay, so the new employer gets an approval of 140 on their end. So what will happen to this 140 that
you'll have two I-140s alive, and you will carry the earliest priority date. No question about it.
Okay. And how about the designation wise? Like if I had the 140 approved for software engineer, can I port it to a business analyst position kind of thing? Can I retain the priority dates?
Yes, the priority date retention does not require same or similar job. You could, from a doctor, become a computer engineer. You can still carry the same priority date. The same or similar jobs occur only when you use AC-21 portability.
Oh, okay. So in this case, if I have to port 140, then the designation does not matter.
No problem. Okay.
Okay, perfect. Thank you very much, sir.
You're welcome, sir. Okay, while we were talking, three more hands came up. Guys, please remember, one second. We're not doing new questions, just follow-up questions, please. If you raised your hand by mistake, put *5 again, press *5, and you'll be, the hand will go down. I won't have time for new questions, only follow-ups. Now I'm going to Ohio. Ohio, please go ahead. Ohio.
Hi, this question is regarding my cap, H1 cap. Once I received 140 and I finished my 180 days and I changed my status from H1 to H4, if I have to come back to H1 again, do I have to have my 6-year cap rule, or can I just apply at any time?
Well,
Does my previous
I understand your question. Because you changed from H1 to H4 does not in any way restrict your right to use that same I-140 to get a 3-year H1 approval as long as you get it within 6 years of your approval of the earlier H1. So no problem. You can come back to H1 if you decide to do it in a next 4 or 5 years. You can come back to H1 and get 3-year H1 without being subject to the quota. Okay?
Right, but my first 6-year term is finishing this year. Do I have to apply for H1 extension and then change to H4?
No,
Can I
no,
just
no,
change to
no,
H4?
no. You can change to H4 today and still have the same benefit tomorrow. Okay.
Does that rule apply if I move within 6 months, like without finishing 180 days?
Yes,
If I have to
yes.
change to H4,
You are still given that benefit even though you moved within 180 days. As long as the I-140 remained approved for 180 days, whether you were working with that employer or a future employer doesn't matter.
Oh, that's nice. And when I have to come back to H1, I don't have to have my previous H1 approved within 6 years, right?
That is correct.
That is fine.
That is correct. Yes, ma'am.
Even if I apply after 7 years too.
Yes, ma'am. You're okay.
Oh,
all right. Good luck.
Thank you.
You're welcome. Okay, let's go to the last 2 questions on this. Let's go to Wisconsin. Wisconsin, go ahead, please.
Quick question, sir. This new set of regulations, the I-140 regulations,
yes, sir.
They are valid retroactively, right? I mean,
no. Hang on. They're not. Hang on. Don't confuse it. It's not retroactive. It's just that if you meet the 180-day requirement on January 17th, you are covered, I think.
Okay.
But what if your case was that on January 16th your employer revoked your I-140, you won't be covered on January 17th because on January 17th you didn't meet the requirements.
Right. But if your I-140 was filed previously to January 17th,
yes,
and it is still alive, so after any point after January 17th,
yeah,
I mean, the I-140 itself can be filed previously.
Right. Let me take an example, a very good example. Let us say on January 17th, your I-140 stayed unrevoked for 170 days. So on January 17th, 170 days are up. You just need 10 more days to be safe.
Okay.
Make sense?
Yep. I think.
Okay. Very good. Good luck, sir. Okay, and the last question in this set of questions is from Indiana. My God, everybody's from a different state. Indiana. Yeah, Indiana, go ahead. I can hear you.
Hi, Rajesh.
Hello, sir.
This is a related question to H-4 EAD and I-140.
Sure, go ahead. Go ahead, please.
Yeah, I have an I-140 from Company A, and Company A has sold some of its business. Then I moved to Company B, and Company B has my H1 currently.
Okay.
And then when we moved to Company B, my wife was on H4 and she got H4 EAD and it is valid until 2018.
Okay.
And the scenario here is unfortunately Company B has laid off more than 10-20 people this month. So I'm one of them, and then I know that H1 is not valid anymore for the past 3-4 days. It happened after January 17th, the same day. So I'm assuming it has a 60-day valid period to move to a new employer.
Hang on 1 second. 1 second. The 60-day grace period is not a guarantee. It is something USCIS might consider.
Okay.
Go on.
Okay. So now the question here is, she already started working on H4 EAD, but right now because I'm laid off and they may be notifying to the USCIS, so should she stop working until I find a new employer, or can she continue?
I think the answer to that is she can continue, Now,
Yeah, our original valid date is until 2018. So
yeah, I don't think she'll be able to go all the way to 2018, but I'm
oh,
actually,
I understand that.
right, I'm making a little guess here. I'm not sure about this, but my guess would be she can continue working unless you go past your 60 days and you're not able to find a job. I think then we have a problem.
I have a problem. Okay. So if I find a new job, new employer, then she'll get hired for again reinstated. Then she can just continue with the same EAD, right?
Because
And H4 valid.
I think then we have a claim to the H-4 EAD because there's a possibility government might forgive your up to 60-day out of status issue, and then the H4 EAD and H4 continues to be valid. Therefore, that's a little bit different circumstance than if you went over 60 days.
Okay. So my understanding is the 60 days is a grace period. I don't want to finish it, but I'm still safe, right? I'm still safe to
No, that's a misunderstanding. That's a misunderstanding. No, it is not something that's a guarantee. It is merely a discretionary power given to the USCIS.
Okay. But in this scenario, because we were not notified it's a layoff from the company due to financial conditions, am I eligible for the compelling circumstances EAD criteria?
I think so. I think you could make a case for it. I think so, because an unexpected financial disaster with the company puts you out. I think there is certainly an argument to be made for compelling circumstances EAD.
Okay.
All right.
Okay, thank you.
You're
But
welcome.
I'm still eligible for the extensions based on the previous I-140, right? Because that is still valid from the company A. If I find a company C,
That's
I
right.
still file my period.
That's right.
Okay, thank you very much.
You're welcome. Good luck. Well, guys, it's awful to be in these situations. I feel your pain. Well, let's go to Delaware now. Delaware, go ahead, please. You had a follow-up question.
Yes, one of the girls asked about H4 to H1, H1 to H4
Sure.
and H1 again
Yes.
to H1.
Yes.
Just wanted to know, like, in what conditions we come under cap, like if my 6 years got it, my 6 years I got approved 140 and my 6 years period is over.
Okay.
And if I had an extension,
Well,
so I'll get 3 more years, right?
if you have had, hang on, the cap only comes into play if your H1 approval was more than 6 years ago when you file for a new H1, or actually when a new H1 is adjudicated.
New H1 or even the extensions also. Like
Same idea. Extension or new H1 or transfer, all of them come under the same category for this particular purpose.
So my last H1 extension date till after 6 years.
That is the interesting part. The question is which date do you consider for the last 6 years? And let's say your H1 was approved from 2011 to 2014. USCIS has told us, at least informally, that they consider 6 years from 2014, not from 2011.
Okay, so my 6 years is done. I can have one more extension, and so because my scenario is I'm almost at 5.5 years now.
You can have unlimited extensions, not just a 3-year extension. I'm talking about the quota exemption. As far as extensions are concerned, as long as your I-140 stayed unrevoked for 180 days, you can get unlimited extensions.
Okay, so my scenario is I'm like 5.5 years over. So my last extension was in 2014, and I'm planning to shift to H4. So is it better I do a one more extension because my 140 is approved, so that like my start date will be this year, and then I move to H4 so that I'll have 6 years gap. Like in any case, if I want to move back, I will be within the quota of 6 years, right?
Yeah, I don't know the answer to that question. It certainly seems like better common sense based upon what we are discussing to get an H1 rather than H4 for now. Okay. I gotta move on. Okay, good luck. Okay, one more hand came up. Guys, it doesn't look like I'm going to be able to finish even the posted questions. I've got to leave at 1:30. So let's just do this. This one almost is the first caller who logged in. Okay. This one is New York. New York, go ahead, please. New York? New York? Hello? Area code 914. Go ahead. Okay, I don't know what happened here. All right. I'll put your hand down then. Let's go on to, oh, again, your hand is up. New York, go ahead, please, New York.
Hello, sir.
Yes, sir.
Sorry. So the thing about H1 to H4 and back to H1 thing. So if the H4 EAD thing, so if we apply H4 EAD for future effective date and while we are waiting for H4 and we want to go back, we want to stay with the same H1, can we withdraw our H4 and EAD petition in between after H4 is approved and we are waiting for EAD? When can we withdraw our petition?
No, if your H4 change of status is approved, it cannot be withdrawn.
Mm-hmm.
An approved case cannot be withdrawn.
So before it's been approved, before they send us the notice, we can withdraw it.
Yes, before they adjudicate it. Whether you receive the notice or not is irrelevant. Before they adjudicate it, you can withdraw a change of status request.
Adjudicated means
they decide it in your favor.
Okay.
Once the decision is made.
And one more thing, sir. So to apply labor and green card and all that, it should be 365 days, or there is no limit like that. I mean, to apply labor for a green card to start the process.
Well, you can apply any time.
365 days before?
You can apply any time. I'm not going to spend too much time on that question, but you can apply any time. You can apply any time. Just remember, there are only two circumstances in which you can extend your H1. Either your labor cert was filed a year ago or your I-140 is approved. So those are the only two circumstances. If there's any gap, you'll have to think of other arrangements in the gap, but the green card can go on. Gotta go, okay?
So we can move to H4. Okay.
You can? Yes, of course.
Thank you.
Good luck. Okay. Sorry, guys. This is taking a lot longer than usual. I understand. I think partly because we have so many issues, so many new things. I'll make time for you guys if I can over the weekend or one weekend, and we can go over all the other questions. By the way, I want to note for the record that on 2nd February at 12 p.m., I'm talking with a member of the community on the, what is it called, 212D, not 212D, 212G, is that what it is? The documentation request from the consulate. My mind is mush right now. I'm going to be talking about that, and if you have any questions or you want to participate in it, log in, same number, 202-800-8394, 221G, I think that's the section. Let me just double check. I'm so out of it right now. I had a pretty busy morning. Yeah, it is a 221G where they say you need more documents. Yes, essential information is missing. So basically we'll do a 221G discussion. You go to India or Mexico or Canada, or you are from China or any other country and you got stuck there because government wants more information. How do you handle it? What happens? So we are in reference to an H1 visa specifically. So if you have any 221G questions, log in on 2nd February at 12 p.m. at 202-800-8394. We will not be doing any new questions, just the old ones regarding 221G. Okay, so let me move on to the next frequently asked question. So this one is about serial transfers of H1s when another one is pending. So let's say I'm with employer A on H1 and my I-94 is good for another 3 months. Employer A applied for my extension. Meanwhile, I got a really good offer from employer B, who filed my extension 10 days before my 3 months are up. So in other words, I'm still good for 10 more days. After that, my I-94 expires. Employer A applied for an extension, employer B applied for a transfer, and employer C applied for a transfer after my I-94 has expired. How will this work? Well, first of all, you can choose to ignore any one of these approvals if they come. In order for you to stay in status for employer C, employer B's or employer A's case must be approved because they were both filed while you were still in good status. But if for some reason they are either denied or not yet approved, USCIS will approve the case for employer C but make you go outside USA for visa stamping. So in a series, everything is connected to everything else. I don't know if you remember the physics, circuits, how serial connections, everything, if something in the series breaks, the whole circuit breaks. It's kind of like that. So let's look at the questions from John Rambo. A very interesting name. My H1 started in October 2016 with employer A. December, I got a new job. Employer B started working with B after applying for H1 transfer in premium processing. Transfer is not yet complete. We got an RFE. The future job, employer C. So basically the same idea, which I just talked about. There is a raised hand, and I don't know why. I'm going to put that hand down for now. We need to finish this call, guys. I got to move along. So scenario 1, I get another job, employer C. So he doesn't have it yet, but let's say he gets it. I apply for another H1 transfer, I start working with them. If this transfer is denied, what are my options? You can actually go back to the earlier two cases. You can actually go back to the earlier two employers. USCIS made that clear in one of their memos, I forget which one it was, but they did make it clear that if you're using portability to move over along a chain of cases, and if the chain breaks, you can, and something is still pending, you can go back to one of the other employers in the chain. Scenario 2, I get another job, employer C. I apply for another H1 transfer, but I start working with them only when H1 transfer process actually, this is a little confusing, the size of my screen. Okay, well, right now we don't have time for this. Will this increase the risk of denial? I get another job, I apply for another H1 transfer, but I start working with them only when the H1 transfer process. No, I don't think it increases the risk of denial because you wait for the approval. I don't see any problem with that. Will it increase the risk of denial of transfer application for employer B as it is not completed yet? No, I don't think so. I don't think it has any additional risk. Government is used to, and they have decided to accept these kind of cases, the serial transfers, and their regulations actually talk about these cases. So you should be okay. Star 5, if you have a follow-up question, star 5. One question from Minnesota. One question from Indiana. Okay. All right. Let's go first to Minnesota. Minnesota, go ahead, please.
For scenario 1, you said that if your transfer is denied, you can go back to either employer A or B. But would this not, in one of your calls, you said that if a job at employer A does not exist anymore and you are going to another job at employer C, then you can't really switch back because the job at employer A was already gone. So you left that job, you joined another one, then how can you go back and take the same job?
That is odd, but that's what USCIS said. Remember, immigration law changes very rapidly. What I said 3 months ago may not be true today. So basically, the current thinking of USCIS, as I remember it, I always like to confirm and reconfirm. That's why you have all these disclaimers when you log into these calls. My recollection is that USCIS actually came out and specifically said so, that you can, if in a chain you are working for an employer and that gets denied, you can go back in the chain. It's not a problem. Okay, so it sounds counterintuitive, but I tell you what their reasoning is. Their reasoning is because you are working using AC-21 portability, we don't consider you to be out of status. Okay?
Thank you.
You're welcome. All right, let's go to Indiana. Indiana, go ahead, please.
Rajuji,
G.
the question is about H1 transfers and the time period between two transfers. If we are out of status, like if the H1B is cancelled and moving to a new one in the process, what are the options before the next one files? Now, if they did not file the receipt, there is a gap. So, is there any option for us to maintain the status?
See, remember the 60-day grace period started from January 17th. That is the only option. Watch out for unlawful presence. That's the thing that would concern me. Because if the
There
case
is no other type of visa that we can apply, like B2 or something.
yeah, people do that. It's actually in my blog. There is an entry to maintain status, unexpectedly laid off, how to maintain status. It talks about applying for B2 or an interim visa like that. Sure, it's not guaranteed to work, but at least you've got something going and you're not out of
Not for
status.
work, but to stay and wait until the
Yeah, but
new
if you
employer
are
files.
if you're already out of status, that doesn't help. You've got to file it before you are out of status.
Okay. And then in this, how the I-94 works, like if the I-94 is valid for a year and we transfer, will that be still counted as continuation, or is the I-94 also expired until we file the new receipt?
That's an irrelevant problem. Don't worry about it so much. That's really not a relevant issue. Whether the I-94 continues or not, USCIS will take care of that part. Don't worry about it. Okay?
Okay.
Good luck.
Thank you.
Okay, let's go back to what type of marriages in foreign countries are considered legal in the USA. This actually comes up very frequently. Let me give you the summary of the law, and this is very, very important that you understand this, because I have known at least one case where somebody was prosecuted for fraud because they neglected to disclose a marriage they had entered into in India. They said, well, that was just a religious ceremony. That's not the law. The law is, if a marriage is legal in your country, USCIS will consider it legal unless there is a reason it is forbidden. So default is, if your marriage is legal in your country, it is legal here. But two major exceptions to this are where there's something wrong. One, if the person is a minor. Under US laws, if you get married to a 12-year-old girl or a 13-year-old girl, as a matter of public policy, we don't recognize those marriages. That's one possibility. Haven't really studied this for a while, but I'm thinking of a possibility. Another thing they don't accept, this I know for sure, is something called proxy marriages. What's a proxy marriage? Under Islamic law, I think both for Shias and Sunnis, perhaps also for Ahmadiyas, if husband is on the phone with two adult male witnesses, and wife is on the phone on the other side with two adult male witnesses, and they both say I do and get married, that would be recognized under many countries' Islamic laws. But USA does not recognize proxy marriages. Those are the only exceptions. So then there was a question about, Shrike asked me, there are two types of marriages in my country, statutory marriage and customary marriage. That's true in India. For instance, India has a system of personal laws. Marriages, divorces, inheritance are covered both by statutory as well as what is called uniform laws, as well as religious laws. So when you get married in court, you are going under, from what I remember, Uniform Marriages Act. When you get married in the temple and you do the 7 steps around the fire in a Hindu ceremony, or kabul hai in a Muslim ceremony, or I do in a Christian ceremony, that is acceptable too. So they are both equally valid. Example, the Catholic Church is recognized by the matrimonial causes case law. No, it's more than that. It's I think there's a Christian uniform law, a Christian law as well, Christian marriage law as well. A customary marriage is contracted under traditional laws. Yeah, I know all of that. I used to practice in India, although I haven't done it for almost 30 years. My marriage falls under customary marriage. It can be dissolved. Well, as long as it is not a proxy marriage or there is something else so wrong with it that USA would refuse to acknowledge it, I don't see any problem just because you got married using customary or religious laws or religious procedures. As long as the marriage is recognized in your home country, we will consider it legal in the United States. *5 for any follow-up questions. No new questions. I'm not going to have time. I see some people are logging in. I won't have time for new questions. I can only do follow-up questions today. *5, okay. Can an I-145 be filed without the help of an employer? No, it cannot be. So I have an I-140 approval. I left the employer. Now my priority date is current. I want to file 485 through that employer. You need that employer to have a job open for you and give you a letter saying that. Otherwise, you cannot get the 485 filed through that I-140. *5 if you have a follow-up question. *5. Okay. Next question. What if the employer goes bankrupt? What happens to H-1s and green cards? Well, two different issues and different scenarios. There are several kinds of problems, financial problems that a company can face. Within bankruptcy, there are two. I think one is chapter 7, the other one is 11, something like that. I never can remember these. Sorry, let me just check my tweets also. Okay, these are just retweets. Okay, so going back to, I'm monitoring my Twitter account as I said earlier for those who are just logging in. So if the company stops paying your salary, that's where problems begin. Or you stop having work to do, that's where your problems can begin. If there is an interruption in payment or the work, it can be said that both green card and H-1 are gone. So you have to restart it somewhere else. So the question specifically that K. Sarvanan had was this. I'm on H-1B, I-140 approved from first employer in 2008. I left, second employer filed green card again, got I-140 approved. Then there was an amendment for porting the 2008 priority date. Okay. Now my attorney received the RFE on ability to pay. Employer filed chapter 11 bankruptcy 6 months back and yet to come back. So one of them is a reorganization. I think chapter 11 is a reorganization. 1 second. So chapter 7 and chapter 11, or is it chapter 13? Yeah, that's a reorganization, chapter 11. So they're restructuring their debt. So that may or may not be fatal to your case. My last year W-2 didn't match the I-140 wages. So 2016 total income also is few thousand less than the I-140. What will happen to my green card? Well, the thing is, first of all, your priority date is well protected from 2008. If your I-140 has been approved for more than 180 days, either one of them, you will also keep getting H-1 extensions. Now, one thing I'm not clear about is your 485 pending? Oh yes, it is. So when was it filed? If your 485 is pending 180 days, then you can just take same or similar job anywhere else. Your green card goes on, no problem at all. Okay. There are some things here that make me a little nervous, whether when they filed the I-140, were they having the same issues, and how does that affect your I-140? I think you should talk with your lawyers in detail about that. But otherwise, if you have a situation in which there is a bankruptcy, by itself it doesn't mean the case is over. Okay, any follow-up questions, press *5. I have one hand up already, I don't know why. *5 for any follow-up questions on bankruptcy. So SK, again, I repeat, as long as your I-485 has been pending 180 days and the I-140, when filed, was approvable, the company was doing okay, I don't think you're going to have a problem porting your green card over to a same or similar job somewhere else. Okay, doesn't look like we have another question on this. Another frequently asked question. We have a lot of frequently asked questions. This is probably the most I have seen since we started doing this about 15 or 16 years ago, maybe even 20 years ago. Impact of child turning 21, green card H-4 F1. It's a very typical scenario. Some of the older professionals who have children turning 21, they can't stay on a H4 anymore. What do you do with them? Well, they have to independently acquire status, and F1, of course, is a good choice. They will not be able to inherit your green card unless they are covered by CSPA, Child Status Protection Act. And many of them I know are actually going through two processes. After they've finished their studies, they've gone on to get their own H1s, and the parents have applied for them as well. Remember, a green card holder can apply for an unmarried child. So, Child Status Protection Act works like this. What CSPA does is, it subtracts certain numbers from the child's age. So, for example, in the employment law context, it will subtract the number of days the I-140 stayed pending. And if the child is under 21, they can file a green card with you if your dates are current. That, in a nutshell, is CSPA. But if they are way off, son is turning 21 in August 2018, you will subtract the number of days I-140 was pending from that. And if you can file 485, then you are all okay. Star 5 if there's a follow-up question on this. All right, let's go to, this is California. I have not repeated a state yet. So many different states. California, go ahead, please.
Yes. Good morning, Rajiv.
Hello,
So, what happens in the case when the child is on an EAD and is turning 21?
well, if the child is on EAD, then you are okay, because when you filed the 485, the child was under 21. Right?
Yes, that's right.
Yeah. So when the child was, as far as I understand the law, I don't see why this should be a problem. They can't be on H4, but when they filed the 485, their age froze. They are fine.
Okay.
Okay.
Sounds good.
Good luck.
Thank you.
You're welcome.
Thank you.
Bye. Okay, then there's another one. Another California question. Yeah, California, go ahead, please. California.
Yeah, hi. I'm the one actually who asked this question on the blog.
Okay.
So I'm not very clear like what I need to do now since my child is turning 21 in 2018.
All right. Do you have your green card going?
No, my I-140 is approved, but the party dates are very far.
Okay. Then you need to have your son convert to an F1 through either a change of status request to the government, USCIS, form I-539 along with the I-20 from school, or go for visa stamping outside USA for Canada, Mexico, Jamaica, India, wherever they want to go. Okay. So they need to convert to F1 visa.
Oh, so there is no other option, right?
Not that I know of. No.
Okay. All right.
All right.
Thank you.
You're welcome. By the way, I want to add, we have many clients who went through this. Oh, he hung up. Okay. I just want to assure you that this is not something that I would worry about too much. Okay, let's go on. Then, delay in naturalization. Okay. So my case has been pending. InfoPass appointments have been done. It's stuck in the name check process. What do I do? You know, I've discussed this issue before in naturalization context. There's actually a statutory time, I don't know what it is, 3 months or 4 months, within which the government has to adjudicate your N400. But many courts have held the time begins to run only when the name check is cleared. So until the security is cleared, you can still file under general law. General law says that if there are unreasonable delays, that's Administrative Procedures Act, APA, says if there are delays, you can file a writ of mandamus. These are difficult cases to win. I would discourage it. They're expensive, they're time consuming, and they often lead to the government asking you all kinds of weird questions as a part of the adjudication. Because remember, a writ of mandamus, which is the appropriate remedy for these cases, does not guarantee you a favorable answer. It just guarantees you a timely answer if the court decrees it. So what happens is, court says, okay, you've got to do it within the next 30 days or 40 days or 45 days. Government sends you a list of 10,000 questions. And that's a pattern I've seen. It sounds, they behave like petulant children sometimes, but they've done that. So, should you do something about it? I would go to my congressman's office if I were you. I don't think there is really, you shouldn't go to court as far as I can tell. That, I think it's something you should try to resolve through the legislative means rather than the judiciary. But that's just my guess. *5 if you have a follow-up question. *5. Another frequently asked question. You will notice that we have a lot of these today. From Rahul. Travel during H-1B transfer extension pending. Okay. So let's say I have an H-1B which is being extended. I've got 5 months left on my H-1 and I want to travel and come back while the extension is pending. As long as I was in USA when the extension request was received by USCIS, if I travel outside and I still have a visa to get back in, that's fine. You can travel both during H-1B transfer and extension, not during change of status, because then you would lose the change of status. You can travel during transfer and extension as long as the visa is valid and you were in the United States when the transfer or extension was filed. If you are not there, then you would have to go outside USA for visa stamp. Okay, let's see. Don't worry about the I-94 numbers. People get too bogged down with those. Don't worry about the reconciliation. Don't worry about any of that. That's not your problem. Yes, you should always carry a receipt notice showing that the case is pending. Although remember, the CBP at the airport can look it up just as quickly as you can. So yeah, but carry it anyway. *5 if you have a follow-up question. *5. Okay. Rahulji, are you the same Rahul I've been talking to for the last 8 years or so?
Yeah, I think I'm the same person.
By now we are old friends. I know your name. How are you?
I'm doing good. How are you, sir?
Very good. Happy New Year.
Yeah, Happy New Year. And it was very interesting to know that you have been doing these calls for like over 15 years, you said, right?
Actually, closer to 20. There was a time when there are emergencies, something goes wrong. Sometimes we have, maximum number I have handled is about 600 people on the call. So that took us like all day to do it. Remember that Tri-Valley situation? In one of the calls, we had almost 500-600 people.
Yeah.
So, but tell me what is bothering you?
So the quick question I have is, so in case I'm traveling, my current H1 is with my current employer, which is employer T, okay?
Sure.
But now there is a different employer B, who has filed for my H1 extension based on the 140 which has been approved, right?
Sure. Mm-hmm.
So, but I'm coming back within the validity of my current H1. I'm just going and coming back within the current validity.
Sure, I understand.
Now, at the port of entry, if they see that yes, there is an employer A H1, which is what we are using to come back, but there is a transfer, petition for employer B, can they kind of
No, that's perfectly.
intend to work with?
No,
Is it
that's
employer A or employer B? I mean,
that's perfectly legal. You in fact have the choice of working anywhere you please. So yeah, no, I don't see that as an issue. There was a point of time where Customs and Border Protection was very poorly trained, because remember the history of USCIS, it was INS. Then some officers from INS combined with some other officers from Customs, it became CBP. Customs and Border Protection has officers from Customs with no immigration background. So it became very complicated at the airports. But now it's been a long time. Most of them know what is going on. This is perfectly legal. I don't see any problem with it.
okay. And in this case, even the H4, I mean, my wife who has H4, she can also travel and come back, right? Even if her extensions are pending.
Unless you decide to leave her behind, yes, why not?
Okay. So there shouldn't be a problem there, right?
I don't see any
And the
problem.
I-94 numbers, you don't really have to do
That's
anything,
not
like,
something
they
that
automatically
you
do.
don't need to worry about it. No. Just look at the I-94 expiration date. Don't look at anything else.
Okay.
All right.
Okay.
Good luck.
Okay. Okay. Thank you.
All right. Bye-bye.
Thank you, sir.
Okay. Guys, I repeat, there's no way I'm going to have time for any extra questions. I'm already pressed for time. I think I'm going to go over 1:30. So then, can I start a non-profit while on H-1 visa? Another very frequently asked question. Boy, we have a lot of questions still left. Okay, I'm going to have to run through them, guys. Pennsylvania, I'm sorry, I have a lot of questions to cover. Sit tight. I'll try to get to as many of them as I can. Okay, can I start a non-profit organization while on H-1? Definitely, why not? As long as you're not getting paid in cash or in kind, I don't see any problem with it. Okay. Especially when you're doing it for religious basis or community service, counseling, teaching, seminars. Can they sponsor religious workers? Sure. If they meet the requirement of our visas, they can definitely sponsor other people. But there are some strict requirements for our visas as well. So overall, yeah, I don't think it's a problem, but I would strongly recommend you talk to a lawyer. Make sure you don't go wrong with doing something which could come back and haunt you as illegal work, unauthorized employment. Okay, but in principle, yeah, I don't see any problem with it. Okay, star 5 for a follow-up question. I have one from Pennsylvania up already. I'm not sure what. So star 5 for follow-up questions. Pennsylvania, go ahead, please. Pennsylvania.
Yeah, Rajuji, I had one question posted that was previous to this non-profit organization question.
Did I miss it? Oh no, I'm going to come back to them. I'm going to come back to them. Sit tight. I'm just doing the frequently asked questions first, okay? I'll come back to it. Don't worry.
Okay, yeah, thank you.
Mm-hmm. Your posted questions, I'll definitely answer all of them. No question about it. So right now, I'm not going to invite any discussion on anything other than frequently asked questions. So non-profit is done. Let's go to the next frequently asked question. H-1B expiring, PERM no file, not filed extension, options. So they have given us a lot of scenarios. Let me give you, Ganeshi, I hope you are here and maybe you can clarify your questions. I have to run through this a little bit. But there are only two ways you can get H-1 extension. Only two ways. One is based upon the time your green card has been going on. The other is based upon the stage of your green card. Time and stage. Let's get rid of the easy one, stage based. If your I-140 is approved, we don't care when you started your green card. We'll give you 3-year extension and we'll keep giving them to you. Stage based, I-140 approved. Time based, your PERM must have been filed a year ago, beginning the start date you are requesting on your H-1. So 1 year anniversary, you get your H-1. I-140 approval, you get your H-1. Star 5 if this is not clear. And you will get, anytime you were outside USA, you'll get it back. No question about And if there is a gap, and you say, let's say you have to convert to a student visa or you have to go outside USA, you can come right back once that 1 year or 3 year is available to you. And you will also not be subject to the quota, right? So, all right, let's go on to the next frequently asked question. Trump and employment-based immigration. Well, as I've said before, I am not a fan of Trump. I don't know what this administration is doing. I don't know what they are going to do. Any change in the I-140 EAD rule, they'll have to go through rulemaking. They can suspend regulations that are not yet in operation, but they cannot suspend regulations that are in operation, as far as I know, without rulemaking. Is Trump administration going to make anything worse? We don't know yet. So it all depends upon how they look at legal immigration. And so far, there are at least 2 people in his administration who are against all kinds of immigration, legal or undocumented. But ultimately, I don't know. I think it will be very short-sighted to make a decision on something this important without proper research and contemplation. But to answer your question, I don't know what's going to happen. But it won't happen overnight. We should at least have some time to do something. The times that your attorney is telling you, Sumanji, average time on prevailing wages?
4 months.
Thank you. It's not 7 months, it's 4 months. Other than that, ads and all, it shouldn't be 3 months. All of that, well, I think he's talking about job posting, etc. That should be so about, I think they are a little bit too pessimistic. And also remember, you can file your I-140 premium processing. Okay? So I can't answer asylum cases because I don't do asylum cases. Okay, folks, I'm going to start on the non-frequently asked questions. And I'm going to not be able to answer any new questions. Very sorry about that. We just have too much going on today. Delay in naturalization, travel. So first non-fact is from Catch Ram 12. Transfer of expired H-1B. First entry into USA in 2001 on L-1B. H-1 in cap approved in April 2012. Start date October 1st. Took a vacation 1 month. L-1B. H-1B started on October 2012. Expired 2013. I went back to India, stayed there for 2 years. Came back on L-1E again 2015. I don't think you are subject to the quota. But let's look at first entry in 2007. H-1 applied, approved in 2012. So you were on L-1B visa. Then in 2012, October 2012, you took a vacation, traveled back for 1 month. You stayed for 2 years. That resets your clock. But if you want to be cap exempt, this is not an easy answer. I don't know. There's something called remainder option. Remainder option. The way it works, this is very complicated. I would have to probably look at the regulations very, very carefully with this in mind, as well as any data that the government has produced on this issue. So what is the remainder option? When I'm outside USA for 1 year, let's say I left USA in the 3rd year of my H-1. I'm outside USA for 1 year, I have 2 options. Because my H-1 was approved in the last 6 years, I can come back without being subject to the quota, but then I'll be entitled to only whatever time is remaining on my H-1, subtracting the time that I have already spent in USA. So that will give me 4 years. 2 years I was here on H-1, I left 1 year, I'm outside USA. If I take the remainder option, I've got 4 years. I think your L-1B periods will also be combined there. Okay, that's the part that I'm not sure about. I think your L-1B, L-1A, all those periods are combined together. Second option is, you say, okay, I've been outside USA for 1 year, I want all 6 years of H-1 back. You can get it back, but then you are subject to the quota. Okay, so in your case, I cannot really predict. There are too many variables, and I just don't have the data in front of me to make a good decision. My approach to you is, this is the way I see it. It's a few $1,000s. If the employer wants to spend on you, they could take a chance, try it, see how it works out. Because this, I don't think there's an answer out there for it. I do keep track of everything that's going on, as you might have noticed. I do spend a lot of time reading and writing. Star 5 if there's a follow-up question. Star 5. Okay, this is Pennsylvania. Sir, go ahead.
Yeah. Hello, Raju. This was posted by me.
Yes, sir.
Yeah, thanks for taking up the question.
Of course.
Basically this H1 that I had was from 2012 to 2013. So from 2012, if we consider, so I'm still below 6 years, so 6 years limit, right? So, and also I have some time left combined, like with L1B and H1 combined.
Yeah.
In those 6 years, I still have around 1 month time left. So, considering that, can I use that old H1 from April 2012?
Yeah,
Get an extension with
see, if you were approved in 2012, so even in the worst case scenario, you have till at least 2018. Subtract from them another 2 years because you were physically outside USA. So definitely you got at least, I would say 3 years or so, it looks like to me. If in that time you start another green card, then you can keep extending your case.
No, I have an approved 140.
Then there is no problem. Then even if you had no time left, you would still be entitled to 3-year extension.
Oh, is it? So,
Yeah.
okay. Using my old H1?
Why not? As long as it was approved within the last 6 years, you are entitled to it. So you got 3 years, go for it.
Oh, wow. Okay, that's a good news for me. And if I, basically, if I apply to the new company also, they would ask for some substantiate to my statement. So, can I get wording from an attorney or someone? Like, is there an option like that?
You can play for them this conversation. I think that would be as good as any. And as long as their lawyers follow the logic that I'm following and they agree with me, I don't think there should be a problem. Okay?
Okay, they'll be able to give it in some kind of document or something that this is an option available and you can hire.
Why not?
Kind of thing. Right?
If that's what they do, sure, why not? For me, if I were representing the company or you, I would just talk to them and say, that's the way I see it. You know?
Right. Okay. So there is an option that I can use my old H1 to get an extension based on my current approved I-140.
Actually, you don't even need the old H1. The old H1 you only need to, for it having been approved in the last 6 years, and then you've got the I-140 to get a 3-year extension.
Yeah, but if I want to go in for a new employer, since I am on L1 currently,
doesn't matter.
The new employer has.
Doesn't matter.
Can he get an H1 based on my 140 alone?
Yeah, any I-140 gets you 3-year extension with any employer.
No, not the extension. Like a new H1, can he apply?
Sure.
Just approved.
Sure. These are just names.
Oh, right.
Of course, extension, amendment, transfer. These are all just names. New H1. Basic idea is if an I-140 is approved, you got your 3-year H1. Take it wherever you want to go.
But I thought that only the current employer can apply or extend the H1.
That's why. That's the reason I can make a couple of dollars and still live here in this country. Because you don't know the whole law. If you did, you would fire me.
Yeah.
No worries.
Okay, so last point clarity. Sorry, Rajat, I'm trying to get. So I am an L1 right now. So if I tell my new employer that where I'm applying to, so they will be able to transfer my 140 as well as apply for a new H1 based on the approved.
They don't. They cannot transfer the I-140. That cannot be transferred. They will be able to
transfer in the sense like based on my approved 140 and my priority date.
That is correct. Yes, sir. Okay.
Okay. Perfect. Yeah. Thank you so much.
You're welcome. Good luck, sir. Okay. I hate to be so hurried, but it's gotta be done this way. Peter New, Peter says, currently on H-1B, I-140 approved in September, software developer, I want to switch roles. Same company, but changing the client, taking up new role. Yeah, you'll have to start the I-140 probably at the PERM all over again, but you'll carry the same priority date. The only way you could avoid this, well, not even then. You can put your priority date, Peter, but I think you'll have to start all over again. And just because the second green card doesn't get approved should not automatically negate your existing I-140 as long as you're willing to take the old role upon approval of the green card. You'll be fine. And the employer is willing to give you that role. Star 5 if you have a question. Star 5. Okay, let's go on to the next one. Oh, this is from 3 Idiots. Funsuk Wangadu. Funsuk Wangadu says, last conference call, there's a follow-up. I'm trying to understand changing jobs. What happens? I'm currently with employer A. I-140 was approved. Let's say I keep the job until 2017 and move to employer B in 2017. Priority date becomes current in February. I can still dream, right? Yeah. What are my options? Well, you have to start your PERM all over again. How will these options change if employer B has restarted the green card process on February? Well, the only way you're going to be able to file the 485 with the second employer is if their I-140 is approved and you are ready to file the 485 based upon their I-140 and the priority date that you're bringing in to the table. Okay, so you still have to go through it, and you can file your 485 with the new employer's I-140 only when the new employer's I-140 is approved and the priority dates are current based upon the old priority date. Star 5, there's a question. Last question he had was, can my spouse have the option to get H-4 EAD through my current I-140? If I have moved to employer B, yes. I have made that very clear. Please read my blogs, guys. Post your comments there, post your questions there. I try to answer them within a couple of weeks, sometimes even earlier, but at least within a couple of weeks. Post your questions. We have a expanding knowledge base. So read my blog, please. I invite you to do that. All these questions have been dealt with a long time ago. So yes, to get an H-4 EAD, all you need is one I-140. It doesn't matter whose I-140 it is surviving. Star 5 if there's a follow-up question on this. Star 5. I got 2 questions left. I won't be doing any new questions. I'm sorry, folks. Anik Kapu. So he couldn't dial in the last time. Posting it again to discuss further on the call. Are you here? Press star 5 if you are here. Star 5. Anik, are you here? Press star 5. Still not here. Okay. My graduation from university, US University, employer applied for H-1B April 2010. H-1B was approved, start date of October 2010. Went to India in December, but consulate issued 221G. Seeking further documentation. I'm reminding everybody, 2nd February, 12 p.m., we'll do a call only on 221G, nothing else. 12 p.m., February 2nd, 202-800-8394, our community conference call. Okay. Went to India, couldn't get stamped, decided to stay back, left the company. Okay. On October 2014, somebody wanted to hire me, but then couldn't get the visa stamping done. Now, my wife's company is asking me to work in their US office. Can I transfer my H-1B? And the answer is, I think so. I think so, but I'll tell you what the problem is. USCIS has said, for most people, if they don't get a visa stamping, we don't consider them to be exempt from the gap, unless they got a change of status. And you did get a change of status in 2010. So it looks to me like you are exempt from the cap. You got your H-1B approval. but was it within the last 6 years? Yeah, obviously, because you probably had it from 2010 to 2013. So chances are your H-1B is still cap exempt. See, I remember I told you, so far, informally though, USCIS has been looking at the date to which it continues. So 2010 to 2013. 2013 is within the last 6 years. Therefore, you're okay. I think you just logged in. I see somebody from India. Go ahead. Go ahead, India.
Hi, Rajiv. Yeah, this is Anil. I'm the one who actually posted the question.
Okay, so I'm making a guess here. I think you are cap exempt, and because I'm assuming in 2010 you got approval till 2013, right?
Right.
So
it was till October 2013.
Right. So USCIS has been looking at the date too. So they'll count 3 years, 6 years from October 2013, which brings you to 2019. At least that's what they've been doing so far.
Oh, okay.
Okay. So that's what I'm hoping.
So the extension I got after that, the second employer. So in that the expiry date is 2017 October.
That one I'm not too sure about, because if you don't get a visa stamped, are you still quota exempt? Let's not go there. But if you have an option, take it. I think it should work. Okay.
Yeah, but my problem is I don't have that employer still having a job. So now I have to find a new employer who can transfer it again.
Okay. I think you have time. You should be okay.
Okay, good.
Good luck.
Thanks, Ranjit.
You're welcome. Okay, last question of the day, guys. No new questions. I'm sorry. This is Nikhil K. I-131 and N-470. Family got green card in March 2014. I need to send my 12-year kid to India in June 2017. Nikhil ji, I'll have to look up the law. I don't remember if children that young have to file an I-130 or I-131. N-470 is not available to him because you are not working outside USA for certain stated occupations which are to the benefit of the United States. Can he be eligible for citizenship in 2019? He can't do an N-470. Does he need an I-131? I do not remember, because under certain circumstances, if I recall, the residence of the parents can be imputed to the children. I think the safest thing to do is, if you don't want to look into it further, file his I-131. After that, make sure he keeps coming back to USA before every 6 months, just to be on the safe side. So once in 4 or 5 months, let him come to USA. And I think that would be the way to do it. You got your green card in March 2014. So as long as he's got 2.5 years of physical presence and no extended stay of 1 year or more, he should be able to file for naturalization. *5 if you are here. My last question of the day. *5 if you are here. Okay, folks. One more question. Let's get that. This is Illinois. Illinois, go ahead, please.
Yeah, hi Rajiv. Actually, I raised this question. So I just want to know that if me and my wife, if we get the citizenship, then will there be any issue if my kid is not here for more than 1 year?
Yeah, because if you are gone for 1 year, then your stay is interrupted for naturalization. So you have to start your. Yeah, go ahead.
No, me and my wife will stay here. Okay, but we'll get the citizenship in 2019. But if my kid is out of country for more than 1 year, so can I pass on my citizenship to my kid?
Oh, you mean, can I do? Read the instructions on Form N600. Read the instructions. I think it's an N600. See what it says. I don't know the answer off the top of my head. You might be able to, but there are some residence requirements there. I don't remember the entire law off the top of my head. Look at Form N600. Okay.
Okay.
I'm gonna make one accommodation for one community member who's sent me an email. So you know what? I think I should move the emails here so that people can't see. I'll do because you've been laid off. Let me see if I can accommodate you. That's the only one I'm doing. Last call. So let's see. How do I get to it? Different screen. What is the question? Let's see. What has happened is there was a layoff. Last date is March 31st. Okay. Until March 31st, I would get paid by regular payroll. I'm in India right now. I've scheduled a visitor visa interview appointment for myself because I want to bring my parents for touring USA. I thought I would use a visitor visa so that I do not use the allotted time on H-1B. If they give you a tourist visa, sure, why not? I was planning to get married and bring my wife on H-4. My job ends in 2 months. I wouldn't do an H-4 for 2 months. I just think I think you'll be better off. Don't get any fictitious letters or anything that doesn't reflect the truth. I would definitely want you to get another H-1 and then bring her here on H-4. But if you want to convert yourself to a tourist visa, I don't see any problem there. *5 if you have a question. *5, and this will be the last call we'll be doing. Okay. Please try to be concise. Let's stick to the main points and we'll take it from there, okay? I do have to run. I'm already about 20 minutes late. Go ahead, please. Go ahead, sir. Hello, India.
Thank you.
Yeah.
I just wanted the clarification about the H-4. I already have a proof of letter of employment from the employer.
See, here's my problem. Sir, here's my problem. I think subsequent events after you got the letter have rendered that letter suspect, if not misleading. I don't think you should use that. If you were my client, I would not let you use it.
Oh, okay. Okay.
Okay?
All right.
What else?
All right. Okay.
Good luck and congratulations on your marriage.
Thank you, sir.
All right. Bye-bye. Guys, I'll talk to you all again in 2 weeks. As always, I absolutely 100% enjoy being with you, but sometimes I'm pressed for time, so I only have an hour, not more. Hopefully we'll have more time. Once again, come join me on February 2nd at 12 p.m., same phone number, if you have any questions about 221G. That's all we'll be talking about. Goodbye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.